Hey, Justine. Hi, John. Oh, I have to see Dan. Hi. Justin, can you hear me?
Yes.
Okay. Yes, I think that's fine. John.
All right. I'm going to go grab some water before we get started.
Hey, Frank, yeah. Hey, good afternoon, everybody. We have a few more people waiting to join, so we will give it just a few more minutes and then we'll get started. Thank you. All right, we'll go ahead and we'll get started. I believe we're recording this, so if anybody's late joining, we'll be able to share it with them later. So my name is John Wasden. I'm an immigration attorney that does federal court litigation. I started off in the government, working the Justice Department and USCIS at headquarters level. And then at the beginning of the first Trump administration, I had all the fun I could handle in USCIS and left and went into private practice. So one of the things that we took on really hard in the first Trump administration was the exceedingly long delays in H-4 extension and EAD adjudication. And it's got a long history. So I thought it would be best if we start off with the history and kind of go to the present day of what's happening and what the strategy is to combat this and to protect everybody's jobs and EADs. So in the first Trump administration, they came out in 2018 with a requirement that required all H-4s, L-2s, and dependents on employment-based visas to get new biometrics prior to adjudication of their H-4 extension and thus the EAD. That broke up what was the traditional standard practice of concurrent processing of the H-1B with the H-4. So at the same time they create this biometric requirement, they intentionally don't staff the ASCs that do the biometrics. And they scale back and limit drastically the number of appointments that they're offering, which created these massive backlogs in the biometrics appointments and completions, which led to massive delays in the adjudication of the H-4 and the EAD. So that obviously kicked people out of their jobs. And we had people that were out of jobs for over a year waiting for USCIS to get their act together and to take care of their adjudications. What became pretty obvious early on is that this was an intentional move. It just like this current interim final rule is very intentional. It's an attempt to take away employment authorization from as many of you as possible. So in the first Trump administration, the way we fought this was with mandamus litigation. And we did this because there wasn't really a clear regulation that was overtly causing the damage or the harm that we could challenge. It's a little different this time around. But we did, in the mandamus litigation, we said the delay was unreasonable and unlawful because, the biometrics requirement that is causing the delay was actually a ruse. It wasn't a legitimate issue, and it was created out of bad faith. So we litigated this issue for close to 2 years, and then we caught the government in a lie. They put in a declaration in court that we were able to prove was demonstrably false, which led to a settlement. And that settlement was they would return to concurrent processing. They would give L2s, employment authorization incident to status, which means they don't have to apply for an EAD. And it allowed auto extension for H4s in certain conditions, with the understanding that they would go and regulate and create auto extension globally for everybody because the backlogs were so long. So that's where we were until last week, is we had auto extension that went up to 540 days for people, which gave even USCIS enough time to adjudicate a simple benefits request, which the only thing that's required in that benefit adjudication is, are you married to an H1, or are you eligible for the employment authorization card in some different way? So what we learned in that first mandamus litigation in the first Trump administration is that there's a lot of publicly available data out there that USCIS has given us, and they've given to the public. And a lot of that's very, very useful. And this time around, we intend on using a lot of that again. But the problem is with a mandamus case, and all mandamus cases are the same regardless of the benefit type or the application type. Every time what the government does is they come into court, they have a declaration from an agency official saying, this is the way we process these. These are getting done in the ordinary course. The plaintiff in this case just wants to jump ahead of the line, and there's no unreasonable delay here. If you don't have evidence combating that, then you're in a tough spot most of the time. We were lucky last time because we caught the government lying. This time around, from the lessons learned, we realized we need to do some very in-depth FOIAs, Freedom of Information Act requests. And those Freedom of Information Act requests go into very, very granular data about processing for your particular benefit type. So that's the one thing that we've learned that is absolutely essential. And it's important to file those FOIAs at the time of you file your application for the benefit, because the timelines with the court, and we'll get to that at the end and our strategy to discussion. All right, so Trump administration 2.0 comes about, and this time it's a little different. They don't come up with this obscure general requirement for biometrics. They just come out guns blazing and say, yeah, Biden came out with this auto extension policy that was permanent in January. It's now October. We're going to do away with that because situations have changed. Now, the regulation that they created, it's just to put it into context, the normal way that regulations are done is the government creates what's called a notice of proposed rulemaking, and they publish it in the Federal Register. And they say, you have 30 days to comment on this proposed rule. People comment on the proposed rule, and at that point, the rule is not enforceable, it's not in effect, it's subject to change. Then, after the comments are taken, they have to analyze those comments and make sure there's nothing in those comments that undercuts the rationale for the rule or the exact nature of the rule. And then they publish a final rule. And then the final rule has an implementation date that's typically about a month afterwards. So they didn't follow that normal process this time around. They went through what's called good cause or emergency rulemaking procedures. And they went directly to what's called an interim final rule, which means we're releasing this rule today, it's effective today, and henceforth, this is what the rule's going to be. If you want to comment, you can comment still. And, we will accept those comments, but the rule's not changing. So the standards for emergency rulemaking are quite high, actually. the government has a very high burden. The way the courts describe it is an exceedingly high burden to justify bypassing notice and comment. And it's usually for things like, changing safety regulations in airplanes, things that are going to cause an immediate impact on people's lives, like death, avoiding, catastrophic events, or to deal with emergency situations like a natural disaster. So those types of things justify emergency rulemaking. And this situation is a little more humorous, I guess, if it wasn't so drastic. But I think Justin will get into that here in a little bit. But yeah, so the other issue that the government's got here is when you create a new regulation, as they did in January, that it solidified the auto extension. If you're going to come and do a 180, there's an additional burden that you have to face. And that additional burden you have to go through with data, and you have to go through with new facts justifying the complete about face that you've done. And something Justin will probably touch on as well, it just doesn't exist in this case. But at the heart of it, of all rulemaking, whether it's emergency or not, the government has one primary objective, which is they have to consider the important aspects of the problem, is the way the courts phrase it. And that would be things like the economic impact, whether or not the rule is justified, or if there's other less intrusive or less damaging ways to accomplish the same objective. Things like that they have to consider before doing the rulemaking. Again, all these things they completely blew past. But yeah, the facts of the current rulemaking are something I think Justin is well suited to speak to and give us an overview on.
Yeah. So
Justin, you're mute.
Oh, you can't hear me?
You're muted.
Still? That's weird. How's that?
There you go.
There we go. Technology.
Yeah.
Okay. So the issue is what's changed, right? What's different?
All right. Well, looks like I will have to take Justin's role. Sorry, Justin, I'm not hearing you.
Oh, that's weird. Let me try and figure out my microphone.
All right. Well, I'll go ahead and take over here. All right. So the government's justification for the rulemaking here was that there was this emergency, this threat of invasion and national security. The only real emergency fact or basis that they had to justify this is, oh, wait, 1 second. So you guys can hear Justin, but I can't. Is that what's going on? Just give me a thumbs up.
He's audible. He's audible.
Okay.
You guys
Folks, if you guys can hear Justin, then I'm going to stop, and I'm just going to take it on faith that he's doing everything perfectly well, and just signal me when you're good. I don't know what's happening here. This is odd.
Well, that is bizarre. Okay, yeah, I'll try to be quick, and hopefully I do a good job. Like John was saying, when you do a complete 180, you have to establish what is new or what is different with the current government situation. And according to this interim final rule, what is now different is that the Biden administration let a slew of people into this country, just an incredible amount of people, so many people coming in requesting EADs, that these people have just not been properly vetted. That's essentially the argument. Now, the EADs obviously range across the spectrum, right? They're talking about EADs for people that are here for under temporary protected status, maybe EADs affiliated with asylum applications, not necessarily the same type of situation as someone that's on an H-4 EAD. However, the government is claiming that by putting everyone in one bucket, they're going to streamline and simplify this process rather than piecemeal and saying, we're going to do the H-4s this way, TPS this way, green card holders this way, okay? So they're saying everyone has to be vetted again, right? They have to be looked at again. And by allowing them to have work authorization, there could be a potential harm, a national security harm. So here is where things get rather ridiculous. What is the national security harm under which they're claiming that the rule must be put into effect? They cite to an incident in Denver, Colorado, in which one individual who was in the country, who had an EAD at one point, attacked people during a peaceful protest that were Jewish people, okay? This one person and this one incident is seen as the righteous justification to eliminate H4 EAD renewals and all other kind of renewal, the automatic extensions for the renewal process, under this guise that this incident shows that there could be a possibility of repeated incidents by other individuals. And as silly as that sounds, it is truthfully cited again and again throughout the IFR as a justification that national security trumps any other interest in putting forth this rule. And it's ridiculous. I mean, truthfully, it is absolutely ridiculous, but it is what they're saying is why they need to jump the line, why they're not going through normal processes, why they're not implementing a rule that goes through normal notice and commenting period, but rather this is the impetus for it, saying national security and the need to vet individuals before they're given a new opportunity for work authorization. What is absolutely ludicrous and silly about that for most of these categories, let alone the H4 holders themselves, these individuals have already been vetted, right? You're vetted when you apply for a visa at the consulate. You're vetted when you come into the United States. When you go through CBP, you're vetted at the time you're H4 itself as you apply for an extension. Your status is reviewed during those opportunities. The idea that this also means that your auto renewal for your work authorization when you have timely filed must also be stopped for vetting is ludicrous. And they have very little justification to it other than this belief that the Biden administration has created a problem, that there's a bunch of people here and we don't think the Biden administration vetted everybody properly. So as a result, we have to step in and do it ourselves. And as a result, we have to get rid of this. So what is the new data points or the facts that allegedly justify this process? Nothing really. There's really nothing that they say definitively that says we need to create this outside of national security interests outweigh any of the harm that's going on. What is ridiculous about this, outside of the fact that it's ridiculous in its own nature, is the fact that there is nothing in this rule that says if you follow what they say, meaning you file for your EAD renewal a full 6 months before the expiration, that they will adjudicate it before its expiration. So no guarantee made by the government that even if you follow what they ask you to do and apply as early as possible, that you will have your EAD in hand at the expiration point, which is ridiculous. And like John spoke to in regards to the previous mandamus actions that were necessary, it's what happened. Inevitably, people began losing their jobs because they went over the threshold of this timeline. People still didn't have their jobs and their employers couldn't hang on. That's the point. If you dig hard enough into this IFR, there's literally a part where they talk about what the impact of it will be on the economy. And they talk about employers needing to deal with the fact that someone loses their work authorization. What is their solve to this issue? Well, the employer can hire someone else, or the employer can transfer the work to another individual. That's their workaround or solution. And it's ludicrous. It's nonsensical. And the point of it is, like John touched on at the beginning of this, it has nothing to do with national security. It has nothing to do with vetting individuals. It has to do with slowing down legal immigration and putting people who are in this country legally in a circumstance where they cannot continue working and supporting their families. So this moves into the considerations, or the farce of the considerations, that they have brought up when looking into whether or not to put this in. The economic impact of it. They have basically said that, again, a notice and comment period going through the traditional form of rulemaking can't happen because of public safety. They insanely note that people need to be revetted again because of remunerations, claiming that people who are in this country during the extension, the auto renewal period, might be sending money out to other countries that could fund terrorism. Do they cite data for this? Do they show you anything, any cases or examples of this? No, it's literally just a claim. Furthermore, they go into detail about how 19.2% of the US workforce currently is foreign born. Now, how does it help the community? How does it help the country or the economy if a sizable portion of that 19.2 lose the ability to work? Not only are those individuals losing the ability to support their families, but they're also losing the ability to put money back into the economy. So when you look at it from those angles, it truly doesn't make sense. And just to kind of put a button on this, the other thing that they utilize here as a justification for the implementation of this policy is the idea that employers are somehow subject or at risk of employing individuals who are not authorized to work, because the employees are the ones that control the circumstance as to how the employer is aware that the individual has work authorization. That is ludicrous. We have clients that we represent who ask us all the time whether or not someone has work authorization or they're able to continue working subject to the auto extension. There are parameters in place that all kinds of companies, regardless of their size or scope, are utilizing to ensure that they are compliant, be that through the need for I-9 re-verification or the receipt of any necessary documents to show that the people are able to continue working. It's a nonsensical argument, but when they have so little to draw from, it's what they're going to draw off of. And that's it. In a nutshell, this is an idea that the previous administration was about letting people come into this country and work without being vetted. The current administration is about national security because there was one guy who attacked a group of people that had an EAD. And that's pretty much their basis. And with that being their basis, I'll turn it back over to John in regards to what the litigation strategy is moving forward based on that.
So thank you, Justin. So John, now that we have got the background, for those who are wondering what they should be doing right now, what is going to be the first step? Either it could be from employer's perspective or the employees.
Now he's muted.
Oh. John, you're on the mute.
All right. How's that? All right.
Yeah,
if you have an EAD application that has been filed after the effective date, the first thing you need to do, and do it very quickly, is reach out and get the FOIA information of what you need to put in your request. And it's something that we do for clients all the time. What you're looking for is a way to track all of the applications that are similarly situated going through the service center that's handling your case, and show whether or not they are actually doing it as they say they are doing it, and show also that the amount of petitions in, petitions out, and show if there's a justification for the backlog and for the slowdown. Since Trump came into office, these adjudications have exploded in terms of processing time, and there has to be some justification or rationale for why that is. But us just saying that they've gone up substantially is a lot less persuasive than us having evidence from the agency itself that says this is what's happening. But that's if we have to go to mandamus. That's our backup plan. Our primary plan is to stop this thing in its tracks. And we do that through what's called a facial attack on the regulation. So when a regulation comes out and it's new, you can litigate and you can challenge it and you can try and stop it. So the way we do that in this interim final is, and with any regulation really, is you look at the evidence in the administrative record. Usually there's a ton of data, a ton of information that the government puts in with a notice of proposed rulemaking or the interim final reg. And then people put additional data in through the comments and additional arguments and critiques. What we're looking to do is get comments put into the rulemaking while they are accepting comments. And then as soon as comment period closes, go to court and sue. But we want to put in our evidence and our documentation to refute each of the points that the government is relying on. So when we go to court, we have that right there in front of us. It's part of the administrative record. and they can't try and use any procedural tools to avoid the judge looking at the good data that is out there. So the lawsuit on the facial attack will proceed on a couple of different fronts. The first one will be it should be invalidated because there is no emergency justifying this emergency rulemaking process. Honestly, I think that one is probably very solid. There's good case law in every court around the country about this. They just can't bypass notice and comment because it would be inconvenient for them to do it, or there's some political motive that they have that supersedes taking time. They have to go through the comment process unless there's a legitimate emergency. The other issue is the way that they describe the process in the IFR is disingenuous, to put it best, completely dishonest, to be more accurate. The way they're describing the vetting process is they're painting a picture of the government not having any idea about anything you're doing until you file an application to extend or renew your EAD. And only then are they vetting you. Only then are they looking into whether or not you're eligible or if there's some disqualifying mark against you. The reality is there are a couple of different systems they have, Atlas and Falcon. They have the ability to see things in real time. And we've seen that happen. You see it happen in the news all the time. Somebody who's in lawful immigration status, out of the blue, gets flagged, gets their visa revoked, and they get hauled into immigration court and removed. And they haven't applied for anything new. They're not getting vetted in that instant. There is just data and publicly available information that they strip from other databases. They get fed to the agency and alert whether or not somebody has an issue, whether there's a security threat, a criminal problem, you name it. They know in real time. And so for them to say that it's going to take them an additional up to 540 days to determine whether or not you have a criminal background that needs to be vetted is, like I say, dishonest. So that's one of the issues that we're hit on, is the existing technology doesn't justify the rule. Yeah, the stated need for this is overcome by what the agency already has at its disposal. The other part that we want to hit on is the economic impact. Yeah, the agency is required to take a look at the important aspects of the problem. Economic impact here is massive. So just, you look at the H-4s and the green card EAD holders just alone. Those people have been vetted multiple times already. They've been, vetted every time they file an application, every time they go for stamping. Some of them have been vetted multiple times over 2 decades, if they're an H1 or H4, going through this process. So, the economic impact they have is these folks in the green card EADs, as well as the H4 categories, are highly educated as a general rule. They are, very, master's degree is very common amongst them. They're working in, things like physicians, dentists, business owners, a variety of fields that are demanding and in need in their communities. If you take away the ability for these people to work, let's say if you're a physician working in a underserved area, or you're on your residency or something like that, you're not able to be replaced so easily as they've described in the rulemaking. Your employer, your hospital, your practice group, if you're that physician or dentist or whatever, can't just go out on the yellow pages and say, hey, we need a new doctor. Come on over. Come move to some rural, underserved area that nobody wants to live in and practice medicine here. That's just not something that they can do on the fly. And we want to articulate, for the court, how flawed the analysis or the justification for this is, showing real world examples. And here is where we really need participation on your end. We need people who have those types of jobs that can't be easily replaced, and we need them to provide comments to the rule so that when we go to court, we can highlight these examples and we can show, these are real world people. These are real world examples. We also need your participation to notify other people. You're all members of social media groups. You're all out there. Broadcast this information. We'll be doing another webinar for people to try and get as many people involved as we can so that we are as ready as we can be to beat this thing up front so that we don't have to get to a point where we're doing mandamus. The procedural posture will be going on the facial attack as a preliminary injunction, or in the alternative, a motion for expedited summary judgment. All of this should wrap up with a decision from the court on these fast track practices before we hit the 180-day mark of the rule being implemented, which means if we stop it in place, auto extension comes back into being, and nobody has to worry about filing mandamus cases. When we did this the first time, we probably got EADs and H4 status for well over probably 2,000 to 3,000 people. And we were filing mandamuses nonstop, just over and over and over again, and litigating these issues. I mean, if we can avoid that, everybody's happier. And you guys definitely are happier if we can avoid that battle. But as a backup, worst case scenario, we file the case and we get assigned a random judge that happens to be a Trump appointee, and we have to litigate this thing all the way out of district court and then go to the appellate court. Then our backup plan is mandamus, and that is where the FOIA comes into play. So as soon as you're filing your extension or your renewal, file the FOIA. And the Freedom of Information Act is something we can help you with. I mean, if you need somebody to file your extension, we can do that as well. But the Freedom of Information Act has to be done in a very particular and precise way to get exactly what we will need for the mandamus case. And we're really just going after, like I say, granular processing data, stuff that shows, the transition from timely adjudications to ridiculously long adjudications over a period of time, and whether or not they're actually doing first in, first out adjudications. And then why those FOIAs are important is, this shouldn't shock anybody. USCIS is not going to give us that information willingly. So what we have to do is we have to go to court. So when we file a suit, we file a lawsuit directing the government to give us that data through FOIA. And the court can order them to give us that data. At the same time, in the same lawsuit, we file the mandamus case. And so both the FOIA and the mandamus are going in parallel, which means that the government can't put in their declaration that is unsupported by facts or evidence saying, oh, we're doing this in the normal course, because we're going to get that data in a court order. Every time we've done a mandamus case this way with the processing data FOIA with mandamus, the government settles and they give us what we were asking for in the litigation. They make a decision on the adjudication because they desperately do not want to give us this data. Almost equally as bad as they don't want to disclose what's actually happening behind the curtain. If they fight a FOIA case and lose, they have to pay your attorney fees. And USCIS and Stephen Miller would rather do a whole lot of things like, walk through hell on fire without shoes and do miserable things other than give me a single dime. And so that's just a very perverse incentive that we take advantage of in litigation, is using the threat of having to pay our attorney fees if they fight the case. So like I say, this is where your help is needed. We need, great stories to tell for the comments. And, if you want to shoot us an email, it's support@wasden.law. We can look through your comments and get with you and help you create a good statement and tell you what kind of information that we would like to be able to gather about you and about your work and about your employer that we can put into the comments. Talk to your employers now, see if they'd be willing to support you by writing a letter describing how irreplaceable you are. And that just because, your position becomes available does not mean they're going to be able to fill that position. The other thing is, we're doing this on what they call speculation or spec. We also have a GoFundMe that we've got. So pass that around to your friends. Like I said, you got social media contacts. We're not asking individual plaintiffs to provide money in order to get relief. That is one model that has been tried before by folks. This is something where if we win, everybody gets the benefit. So it doesn't make sense for just a few people, to pay, so if we can have a community funding effort, it's more fair and it makes more sense. Ideally, what we'd like is plaintiffs for the lawsuit that will be the anchors for the case. And in order to file a lawsuit in a particular area, you need somebody living in that area. And so where we would want to file this case is out on the West Coast, either Northern California. Seattle would be the best possible place to file this, and bring it there. And to do that, we would need a plaintiff that lives in one of those locations. So again, please exhaust your social media contacts. I understand the fear of retaliation with the government. A lot of people have voiced that, and Trump hasn't done much to quell those fears. He's kind of exacerbated that fear. So we can file for you anonymously as what's called a DOE plaintiff. So that is one option we can do, is just to protect your identity, so that if somebody does a name search for you, you don't pop up on the internet, and the government doesn't know you're suing. In this case, the only people that will know you're suing is us, the judge, and you. So that is one issue to consider if you want to participate. If there's something that's holding you back, I think that's a good remedy for that fear. So like I say, the ideal locations would be Northern California, Seattle, or really anywhere on the West Coast. San Diego, LA, I guess. LA's, sorry if there's anybody living in LA, it's my least favorite city in America. So if we can avoid that, that'd be great. But that's where we're at right now. And happy to discuss further. We'll probably be having another webinar to hit on this a little later, probably next week. So we can send that link out around if you want to reattend, or if you want to send it to other people to participate. That'd be excellent. So do we have any questions, Swapna?
Yes, John, like I have already seen people commenting here. So John, while we talk about these EADs, we have two set of categories of EADs again. Somebody who is tied up with the employers and somebody who have their own incorporations. So do you think this rule will affect these type of individuals differently, or it's going to be same?
So if you file after the effective date, you can't work once your EAD expires. So there is no auto extension. So that includes self-employment, that includes direct employment, through a company. It's going to impact everybody, with the exception of OPT students, pretty much, and TPS. It's going to affect just about everybody.
But John, we already know that like in self-employed people, we have doctors, other medical practitioners whom the community needs the most. So do you really think what kind of consequences they will face if they have to continue working?
Well, they won't be able to work legally. And if they do work without authorization, that's going to cause them more headaches later on if they want to stay in the US. So that's why we want to focus on those folks, especially the physicians, the business owners, things that do actually have an irreparable harm if they lose their job. We want to focus on them in the case to show why this rule was ill-conceived and poorly executed. Because there's nothing those people can do. They're just going to be in a no-win situation. They either continue working and face being removed for unlawful employment because they're inadmissible to the US, or they stop working, their patients suffer, their business collapses.
Absolutely, I could already start feeling their pain. So we already have a couple of questions here, John. So the first question here is the current H4 EAD is still valid 15th November. We have couriered my I-765 extension, that is H4 EAD extension, on October 29th, and USCIS has received it on October 30th, 8:30 a.m. in the morning. They have really specified the timing. As I'm affected now due to the new rule, is there any way to expedite my case, or what would be the next step I need to follow?
FOIA. Yeah, just get ready for the worst case scenario. Do a Freedom of Information Act request, and just be ready to fight it out. But work with us on this interim final rule facial attack, because if we win on the facial attack, it's going to be over for you quicker. But right now, I'd say if you file after the effective date, or they receive it after the effective date, and you expire on the 15th, that's going to be a problem. You're not going to be able to work after the 15th.
This looks like, the courier reached and they accepted on the date of October 30th, 8:30 in the morning. So still it counts, or usually it is affected the next day?
So, Justin, you want to talk about the receipt rules for USCIS on that?
Yeah, I mean, the receipt date is what governs. So if it went in on 10:30, even if they received it the day before, if there's not a date on there that's before that 10:30 date, then they're going to treat it as if it goes in after the new policy goes into effect, is my understanding.
Absolutely, I think there is no escape. Wish they would have been couriered one day before, at least to save from this situation. So, John, couple of more questions. Justin, if you would like to answer this about the J1 status.
Well, actually, I did want to say they have a question after that where they said, is there any tentative date to file the lawsuit? And I think that's something we should probably touch on, right?
Yes, after November 30th.
November 30th. I think we can always talk about again this lawsuit, and everybody, I can text the contact information and the email ID of Wasden Law, where you can question us and contact the team for more information about the lawsuit as well. So John, I think if you really have more information about the lawsuit, you can go ahead.
Yeah, so we're just going to file the lawsuit as soon as the comment period closes. So it's going to take us some time to get a couple of reports done. One is a report by an economist to go through the economic impact data. The other report is going to be somebody with in-depth firsthand knowledge of the computer systems USCIS and DHS use for real-time monitoring. And once we have those reports, we're going to then be focusing in on individual stories so that we come at them with the scientific, the technical data, as well as the personal stories, and that will be the final product that we put in for the comments. And then somebody asked, sorry, there's a question. Somebody has asked how much they should contribute. Is whatever you're able to comfortably. For the experts alone, I think we're looking at probably around $20,000 for their reports. And then, travel and litigation expenses will start racking up here. So what you can contribute, please do. And then also, just inform your friends, because based on my unscientific guess, just H4s alone, there's probably about 500,000 H4 EAD eligible holders that are going to be impacted by this. So it's a lot of people out there, and work your connections to get people involved, especially get them willing to tell their story.
John, when we talk about this lawsuit, do you think we have to wait for a specific number of people to join this lawsuit, or we can just begin even if we have 5 or 10?
So really the only people that we need to wait for is a couple of people in the right jurisdiction or the right venue for us to file the case. So as soon as we, have our person or people in Seattle or San Francisco, San Diego, or where have you, in the West Coast, then we're good. I'd take Portland too. Portland would be great. But we're good to go and we're good to file once we are locked in. What we don't want to do is be stuck in a venue or a jurisdiction that is typically hostile toward immigration cases. And so, we want to avoid that.
Do you think, like, now about this lawsuit, once we file it in the federal court, do you think it will force the USCIS to produce the EAD cards before the expiration date of the old cards?
It won't force production of the cards. What it'll do is it'll return the state of the law to what it was prior to the rule, which means it'll bring back auto extension. So you'll be able to work on your receipt and it'll be like nothing changed. It'd be like this interim final rule never happened. And so the old state of play would be back in force.
John, hopefully like the auto extension comes in, but like people here have so many doubts, like whether it's going to be back again 540 days or it goes back into the first administration specific to 180-day period.
So the process would be they would vacate the rule and send it back to the agency. And then the agency would actually have to go through the regular rulemaking process, which if you look back to the first Trump administration, they tried to do away with the H-4 EAD through a regulation. And they drafted a regulation, and then they sent it through vetting within the government itself into an office called the Office of Management and Budget. And that's the last stop before it's released to the public for the proposed rule. Office of Management and Budget, what they do is a ton of economic analysis to see if they've complied with all the requirements in the law on economic impact. And they couldn't get that H-4 regulation through OMB. Even Trump's OMB back in the day said, nope, this doesn't fly. You'll get invalidated in court as soon as this is released. They bypassed all that through the interim final rule. So if we go back into regular rulemaking, not only will it take a very, very long time, the chances of them getting through the economic impact analysis is virtually zero. And if it does, our arguments are still good. There's no justification for this rule because they have the technical capacity to do this in real time without having to wait 540 days, to vet somebody. And the economic impact is still there.
I think like people are more connected with the lawsuit here, and I see most following up questions in regards to the lawsuit. So we also have a couple of questions. They would like to talk about the funding here. They say that like how much can someone contribute towards this litigation? Do you expect this rule to be put on hold?
So we're going to go forward. It just if people can contribute to defray the costs, that's great. Experts, travel, legal fees, they all rack up. So whatever you're able to contribute that offsets the cost, that's great.
As it would help a lot of people, I think like every little contribution can help us. But John, like, do you see like any other amendments to this lawsuit or like, any other new lawsuit? What are the fair chances, like the court accepting these or rejecting?
So I think, we go in on a preliminary injunction, or alternative to that would be the expedited summary judgment. I think the odds are very good. If you look at the case law, the way other courts have decided, and this is pretty much true across the board, in whether you're West Coast, middle of the country, or DC, the emergency rulemaking procedures that they've invoked here are not very popular with the courts, and they've created tests for whether or not the government using the procedure is valid or not. And it would shock most people that I know that are in this field if this emergency explanation held water, if the courts sided with them on this. And if we're on a preliminary injunction motion, we're on a very fast docket. We file our motion for preliminary injunction with the complaint. The government's going to have 2 weeks to respond. We have 1 week to reply. Then boom, we're in court. And the good thing about the emergency motions are if like we get a bad judge, if we get a Trump judge that's crazy, then we appeal to the Ninth Circuit Court of Appeals on the West Coast. And there we're on a very quick docket. So everything is lined up to move quickly. The legal arguments are quite, straightforward. I think the law's on our side here. And I think we're in a good spot.
We have so much of clear explanation here about the lawsuits. Thanks for that, John. So we also have a couple of questions here, if you would like to take it up. The H-1B expires on Jan 15th. Same with my spouse, H4 and H4 EAD. My employer did not file my H-1B extension due to the due to the government shutdown impact. The employer says that they cannot file H-1B extension together with H-4 EAD due to some change in paper payments. If I can do ACH or credit card payment, can my employer file H-1B, H-4 and EAD extensions together now after shutdown? This is off the topic. This is off the topic.
That's a little off topic, but I'll go ahead and give you the answer to that. So there's no more, you're not allowed to pay by check anymore. USCIS has done away with that. So that does not preclude you from paying using ACH or a credit card payment. So that your employer is not precluded from bundling the H-1B with the H-4 and the H-4 EAD together. They can do a G-1450 is the form, I believe, that has the credit card payment on it. And they can pay that way, or you can pay that way to submit that fee, or you can do the ACH route. But yeah, there's no reason why you can't file everything together. Now, the thing about that is just the nature of filing it together no longer entitles you to the adjudication where they bundle the H1 with the H4 and the H4 EAD. Clearly, as we've seen with the administration, they're going to split those when they adjudicate them anyway. So no, you're not precluded from doing that, but don't expect to get a benefit from filing all of them together.
Thank you, Justin, though it is off the topic. You looked up. Hope they got the answer. John, I see people looking for more information about the GoFundMe. I'll go ahead and share the information and the link here. So would you like to talk if these guys are eligible about raising or filing for any FOIs?
Yeah, if you are in that category where you've applied after the implementation date, reach out to us. We have a standard FOIA that we can do for you. We just need you to sign the notice of representation so that we can file it on your behalf, and we'll track it, and we will keep on top of the deadlines on that. Ideally, we won't have to resort to that if we win on the facial attack, and that would obviously make everybody happy. But if we have to, we'll at least have that FOIA in process, and it's something that we will be able to use if we have to go to mandamus.
Got it. So John, maybe we can circle back about a few points for the employers. So from the employer standpoint, what should the HR teams or the managers be doing right now with this change?
So right now, file as early as possible, because you're going to need every potential day that you've got. So as soon as you're at that 6-month window, I would file for those extensions.
But these days, due to this current market conditions, I think most of the employers already delayed filing the extensions.
Yeah, and that's one of the problems with the H-1B. If you're an H-1B, is that it's an employer-driven program. So if the employer doesn't file, you're kind of stuck. But other categories like the green card EAD holders, don't waste any time on applying for your extensions.
So do you think the DHS might consider this decision under the public or the legal pressure, or I know it's unpredictable.
Yeah, no, DHS isn't going to change their mind without a court telling them to change their mind. This is all part of their plan. It's been part of their plan since 2017. They're not going to be astounded by our arguments and our comments and say, "Oh, we screwed up." They know exactly what they want to do, and this is intentional. The court's the only thing that's going to stop this.
Hopefully this time, whatever decision they make, it's going to be permanent, because when they announced about the 540 rule extension as well, they made it as a permanent. Do you think like it's weird they coming back and changing the rules again?
Yeah, so there's a really good Supreme Court case, Navarro Motorcars, and what happened in that case is the Department of Transportation had a rule, and then there was a change in administrations, just like we had here, and 6 months later, they flip-flopped and they did the exact opposite of that rule that was just created. And the Supreme Court's like, nope, that doesn't fly. You've got to explain and go through some details to justify the dramatic shift that you've just undergone. And here, there's no data in this rule. They rely on no data. All they rely on is some anecdotes. And so
what about their citations to Fox News articles?
Well,
that is definitely
yeah, like I said, there's no data. There's infotainment maybe, but yeah. So it's going to be. I think they're in a tough spot to justify what they've done here.
They are the rule makers ultimately, or the rule breakers too, if I'm not wrong.
Oh, yeah, they are the rule makers, but even as long as we have a constitutional republic, they still have to follow the rules themselves. And so there are the rules that they have to go through in rulemaking, and they've blown past those. And it's pretty clear from everything that's going on, what's happening here. And let's just say I'm glad I'm not in the Justice Department having to defend these types of cases.
I think I should probably thank you guys always reminding those people about what rules they have made in the past with these kind of lawsuits. But do you really think like they're sending any kind of message, doing all these things, direct or indirect?
From who?
What's DHS exact perspective about this dependent visa orders right now? This is so confusing.
Yeah, so it's really not DHS so much as it is, Stephen Miller and the Trump administration. So you got to understand, there's the career level employees. They don't really care so much about what a particular policy is. The politicals come in with a new administration, and they have things that they want to do to change the world, and they try and get the non-political career folks to implement that. And so DHS itself probably not too geared up about this, but Stephen Miller, Kristi Noem, they definitely are, because it's part of their overall agenda to eliminate as many foreign workers from the US as possible. In their worldview, which isn't really grounded in reality, if they eliminate foreign workers overnight, like mushrooms, US workers will appear to take those jobs. And that's just not reality. And I think most people understand that aren't in a altered sense, if you will, like Stephen Miller.
So looks like we can expect a positive news once the lawsuit is filed. But like, how soon do you think we'll be able to hear from the courts?
So the one thing working against us is the holidays. Courts are like anybody else; they take the holidays off. I think we'd probably, at the outside chance, I think we'd be looking at if the court doesn't give us what's called a TRO, temporary restraining order, that stops it immediately within days. We're looking at sometime into January.
Oh, sometime in the January. Now that we are yet to file this on November 30th, if I'm not wrong. Pretty long, so people might need to resign from their jobs if in case they are with their employers, and the business have to be stopped, right?
Yeah, and that's why I say the first move is the temporary restraining order. If the judge signs off on that, it ends immediately, like within days of filing. The TROs are tough. courts typically don't like to do it because it means that they're making a decision without hearing from the other side. It happens, but it's exceedingly rare. What's more likely is that the court either does a preliminary injunction, which gives both sides a chance to weigh in on the issue, or expedited summary judgment, which is pretty much the same as preliminary injunction.
So, I mean, I just want to understand, like, what about the business which have been affected? Do you think, like, once the judgment is at our end in a positive way, will the government going to help them financially?
No,
Not.
unfortunately, no. So in order to sue the government has to waive what's called sovereign immunity. They have to allow you to sue. And they've only partially waived sovereign immunity for administrative issues like this. You can sue to change the law. You can sue to stop a regulation, but you can't sue for damages caused by the regulation. And so your recourse is limited, unfortunately. But for business owners who are going to have everything come crashing down around them, that is what we call an irreparable harm. And that is something that would justify a TRO, a temporary restraining order, to end this thing very quickly. So if you know people in that category that have, no kidding, we will never recover from this type of injury from losing their jobs, those are folks that we need to talk to, and they need to get their information.
There's no way apart from just waiting to hear from the courts, I think. So I think, like, we are already here ending close to our session. So thank you, John and Justin. But like, you both have already helped us to understand now just what's happening, but what steps we can take moving forward. So are there any closing note from both of you? We would like to hear the final thoughts.
Just the most important thing right now is, give us your story, tell us what's going on, what your situation is, and help us do the comments and spread the word. Do your outreach on social medias as much as possible. We'll be sending out a link for the next webinar. It'll be next week, and just get everybody that on board.
Just anything from your side?
Yeah, just there's strength in numbers, obviously, and the more people we can add into the pot, the more it helps us. So please get the word out. Also, I know that there are some questions that we didn't have an opportunity to get to, some that may actually be outside the scope of the litigation itself. But if you do want to send us an email, support@wasden.law. We can try to help you out with your issues. If needed, we can ask you to schedule a consultation. But I want to let you guys know we are aware of those, and I'm sorry we didn't have an opportunity to get to them. But we will try to if you send us an email.
So thanks, John and Justin. This has been so powerful and insightful as well. So for everybody who has been looking about more information about the next webinar session, stay tuned. We'll send out an emails about the next session, more details about the lawsuit, and I have already just copied the GoFundMe link in the Q&A. Even we'll be able to share with you all over the email. So thanks, John and Justin, again for your time. I think we can end the session here. We can wrap up.
All right, cool. It was good speaking with you all.
Thank you. It's always a pleasure. Thank you, everybody.